Thanks everyone for spending your lunch hour with us. I'm Eileen Springer. I'm an executive and career coach and the founder of Central Park Executive Coaching. And I spend a little bit of time every week here at HAYVN, and it's my haven. I love it here. And I'll just let Alexis introduce herself and then we'll move on.
Oh, thanks very much. So I'm Alexis Brooks. I'm a solo attorney. I've been a member at HAYVN for about 1.5 years, and I've been practicing in the realm of business law for the past 5 years or so. And all of my clients are small businesses, and many of them have business partners. And so I'm happy to be here and talk to you guys about this very important topic. Thanks.
Thanks, Alexis. So we thought before we got started today that we do a little bit of testing of your knowledge just to get us started. So we're going to do a little poll here. And the first question is, what percentage of businesses do you think fail due to conflict between partners? So we'll just let everyone respond to that. Okay, I think everyone, oh no, now we have everyone that's voted. And I will show you the results. And you guys are good. The correct answer actually is 65%. So that's why this is a good thing to, a good halftime to attend, because that's a pretty big percentage. Okay, and now we're going to ask another question. What's the percentage of businesses in the US that are partnerships? There we got one more person to vote. All right. This one was a little trickier. The correct answer is actually 7%. So it's not a large percentage. Okay. Next question is, which of these legal business entities affords the least liability protection to its owners? Okay, and I'll let Alexis speak to this one.
Well, you guys got it right. It is general partnerships. In general, they do not offer as many liability protections as all of those other entities.
Okay. And then our final question. When is it most likely for default rules, legislation, and laws enacted by states to apply to your business? All right, Alexis.
And again, okay, we have a good audience here. When business partners fail to execute a partnership or operating agreement. So that is one of the points we want to drill down on. Thank you.
Great.
Okay.
All right, everyone. Thank you for your participation. So I'm going to get started and just share a few concepts with you about partnerships and what we see from a coaching and relationship perspective and share some insights and some things for you to think about as you think about what's important to you when looking for a business partner. So, as you can imagine, business partnerships are a lot like marriages, with the possibility of it being one of the most important relationships that you choose in life. And if you pick the wrong person, your company can fail before it's ever had a chance to take off. So, like marriages, these relationships can be quite complicated. So, the first thing you want to ask yourself is, do you really want or need a business partner? And I would encourage anyone thinking about this to think carefully about it and not jump into a partnership too quickly. And if you do decide to have a partner, ensure that you have a shared mission and vision. And at the beginning of a relationship is a good time to think about bringing in an advisor or a coach to ensure that you're taking the time to really test for compatibility. Partners also need to have psychological safety with one another in order to thrive through the highs and the lows that any business would have over time. And you also want to think about having a clear delineation of responsibility and ownership. Is it going to be 50-50 ownership or 60-40? And also to be clear about the time commitments that are going to be involved. So I've created a list, actually like a top 12 list of the qualities that you would want to look for when you're considering having a partner. And the first would be passion. Um, First and foremost, you want to pick someone that's as passionate as you are and someone willing to work as hard as you are, because actually it's not just about having passion, but it's likely to be obsession that's going to make a business work. The second would be trust and reliability. You want to choose someone you can depend on and look for any red flags that one cannot be trusted, because trust is a non negotiable. And even further to that, integrity is accountability added to honesty. So, honest, clear communication is key. And eventually, everyone makes mistakes. So, the ability to own them and not blame others is important. It's always a good idea to do a few small projects first to get the sense of one's integrity. A third quality is compatibility. It can be tempting to pick someone just like you, but it's wise to pick someone who's everything you are not. So, compatible communication style is also key to ensure that things won't linger and that there's open communication. So, consider compatibility in terms of the business trajectory. You want to share the same vision, for example, where one may want to grow a business at a measured rate and the other may want a quick exit strategy. So the vision must be shared and goals and purpose of the organization must be shared. And this ensures that you could have perseverance over difficult times. You also want to have the ability to build a strong relationship with your partner. If you want to scale your business, you may need an extensive network of potential clients, investors, and industry influencers. So you would want someone that had equal ability or more ability or an understanding of that division before you entered into a partnership. You also want to consider fiscal responsibility of the person you're considering. Select someone who knows how to manage money and hasn't had any serious financial trouble in the past. You want to think about whether or not the person is an innovator, someone who can consistently come up with original and fresh ideas. Another consideration is open-mindedness, someone who is receptive to different perspectives. Additionally, consider one's comfort with risk, someone who balances taking risk with being cautious. Another important consideration is the ability to resolve conflict. Someone with good communication and one who doesn't hold grudges. An important aspect to look for is resilience, and this was mentioned earlier. As a new business, you can certainly expect to have setbacks, so you want to have a partner who won't quit when the going gets tough. Consider someone with complementary skills and personality traits. So, for example, a more introverted founder may benefit from a more extroverted partner who's gregarious and enjoys the spotlight. And then finally, consider someone that challenges you, the person who can inspire you and energize you, and also bring an alternative point of view. So, those are some characteristics to consider when you're thinking through this. And with whatever business you're entering into, you have to expect that there are going to be additional strains that come into play. It could be around courting investors, managing employees, speaking to the public, meeting the bottom line. And these would all be really important things to discuss with someone before you established a partnership. Some of the actions that you could take to develop a healthy relationship in the beginning of a partnership is to first set up a strong foundation. Be proactive, decide what your communication cadence is going to be. Are you going to have weekly meetings? Are you going to talk every day? Um, is there anything that you need to address in terms of the way that you're working together? And be prepared to step back frequently and assess what's working really well and what do you need to change along the way. Another action would be recognizing the power of complementary skill sets as well as mutual admiration. Another is managing conflict like an adult. You can expect to have conflict just as you would in any relationship. So going into this relationship, being prepared to listen and always being respectful is important. And then finally, and I think this is some of the best advice that partners can get, is to take responsibility as an individual. If you want to change the other person, the best thing you can do is to change yourself. So there is no such thing as a perfect partner. And there will be times when you need to be supportive of the other person. And there'll be times when you need their support because not everyone has their life together all the time. So, with all of this in mind, unfortunately, not all partnerships have a great start or a great ending. And understanding the legal components are important as well and essential considerations before entering into a partnership. So I'm now going to turn it over to Alexis, who will share some interesting insights about legal structures for partnerships. Alexis?
Yes, all right. Well, thanks very much. So after you've done all of that homework and the background and the business planning and determining whether you want a business partner and finding that business partner and figuring out what each role and responsibility is going to be, the next logical step, and this talk is going to just be focused on the legalities of a partnership. We'll touch on the various entities that might be appropriate, and then the next step, which would be to build an agreement surrounding your partnership and the operations of your business. Those are the real key takeaways I want to give to you today. Is that in taking the step to form a business partnership, you have an opportunity. And if you don't take it, it's a missed opportunity to give yourself the right structure that's appropriate for the goods or services that you're selling, and for the types of skills that you both bring to the table, and then also take the opportunity to craft an agreement, because the failure to do these things might thrust you into a business, a form or entity that really has no liability protection, or it might, the failure to craft an agreement and execute agreement may mean that your business is subject to default rules. And that's what we put in the poll: default rules that apply in the absence of an agreement. So the starting out point is the best time to sit down and really go over some difficult questions and the terms as to how you're going to run the business and operate your partnership. So next, I want to go into what the legal definition of a partnership is. Now, legal partnerships have been around since the dawn of time. Since business started, thousands of years ago. Our definition of legal partnership has strong ties to business partnerships that were formed in the Middle Ages in Europe, and then fully developed by common law in England, which of course our legal system adopted. So the legal definition of a partnership is an association of persons to carry out as co-owners of a business for profit. So it's an association of persons, which may be individuals or corporations, that have the capacity to contract to carry on as co-owners of a business for profit. If you are operating in that manner, regardless of whether you file paperwork with the Secretary of State, you are deemed in the eyes of law to be a general partnership. And what does that mean? Well, it means that you are jointly and severally liable to one another. And that either partner can contract on behalf of the partnership. So you have to be careful. You may not want to take the step to form an entity and to make an agreement, but if you are carrying on as a partnership, you are one under the eyes of law, and you are subject to these potential liabilities that you could create on behalf of one another and on behalf of the partnership. So what can you do? Well, you can be very deliberate in your decision-making and in your choice of entity. And you can, sit down with an advisor, with an attorney, and you can discuss what type of goods and services you're selling, from where, what your vision is, and how you're going to operate the business. Is there going to be somebody who manages it and somebody who's more of a silent partner? Or are you both doing things, equally from a management perspective? There are many considerations to take a look at, but the key takeaway is to plan, because there is a life cycle. So as you heard from Eileen Springer, 65% fail. Well, and what does that mean? That means somebody walks away, or they argue too much and they dissolve it, or it could mean death, disability, incapacity, or it's bought out. But one thing is for certain: there's a beginning, and then there's going to be an end to your business partnership. So it's fairly certain. So you do need to plan ahead so that there is an exit strategy. That's super important. And it might feel like it's negative. It might feel like you're, with a marriage, it might feel like you're doing the prenup ahead of time. But it's important to know that it will likely end. So let's make it as least painful as possible for everybody. So let's see, the various types of business partner entity. I'm calling them legal entities, because business partnerships can kind of be housed, under various legal entities. One of them being the default general partnership, and then, over the last couple of 100 years, various other partnerships developed through statutes, limited partnerships, whereby there's a general partner and then also limited partners. General partner obviously has more management powers and carries more liability, whereas the limited partner might be more silent, doesn't want a management role, and also you're able to, by contract, limit that person's liability as well. Then there's the limited liability partnership, which you'll see, a lot of professional practices are LLPs. There's the ability to limit the risk of partners to each other and for personal liability for the debts and obligations of the business. An LLP protects each partner from the debts against the partnership arising from professional malpractice lawsuits. And also there's the LLC, which most of my clients form because it's a very flexible, very easy way to start. It has some of the corporate-like protections without the corporate formalities and the cost of drafting bylaws. And it's just more expensive to start a corporation than it is an LLC. But the idea is there is protection from personal liability with some of these other entities that you do not get with a general partnership that is formed by default. So you have an opportunity there to make some choices. So take that opportunity to sit down, educate yourself on what would be the best entity for your business and your partnership. But the top line is the general partnership. There is joint and several liability. Partners they have agency to contract on behalf of the company. So that takes a great deal of trust, and that might be fine, or maybe not. So I don't think there's any reason not to sit down and really explore what the right entity is. And then that brings me to what's the next step? You find your business partner, and then you choose the entity through which to house the business. The next step really is to form an agreement. And whether that's a partnership agreement or an operating agreement, generally they have a lot of the similar terms and conditions that you want to explore. It takes time and it takes energy. And a lot of people, there are plenty, certainly companies who do not take the time and energy and spend the money to craft a good agreement, but it can come back to bite you. So I would say it is pretty essential that you sit down and discuss these matters and document them in an agreement ahead of time. And while templates are available online, the whole purpose of the agreement is to craft it and customize it to your arrangement. And so the way you can do that is by, getting some advice from attorneys, going through kind of the key criteria of an agreement, and you and your business partner kind of hashing out the terms, and then sitting down and executing it eventually. Because sometimes when these things, when they drag on and on, it can hinder the operations of the business. The longer you wait, the harder I think it is. And as we said, it's very important to have an exit plan. So the key terms in any kind of agreement that memorializes a partnership and a company operations include, and again, the failure to do this means that you are subject to the default rules of whatever statutes cover that. So if you're an LLC in Connecticut, it's CULCA, Connecticut Uniform LLC Act. If you're a partnership, then it's the revised Uniform Partnership Act. But in general, you want to memorialize these terms so that you have control over voting and over fiduciary duties that you may be able to choose and carve out for yourselves. So the key terms really are division of work between partners, which you will have already talked about. If you take Eileen's advice, the division of work between partners, the effective date of the agreement, the property that is included in the partnership and how it may be used, the financial contributions by each partner, the sweat equity contributions by the partners and the value of that sweat equity, decision-making that may be made by each partner. It may be that you want to be able to allow each partner to make daily, in the normal course of business decisions, pay bills under $1,000, that type of thing, without having consent by the other partners. And then over a certain amount, you might want some sort of majority consent or consent, unanimous consent. Tax matters and bank account management. Again, the approval process of decisions that require consent from the partners. Proprietary information brought by partners to the company and the business, any restrictive covenants, such as a non-compete or non-solicitation that either partner might be still subject to because of previous obligations, previous employment. How to handle disputes amongst partners, that's huge. So can you write in there that the alternative or the first step is to have a session with a business coach, or mediation versus litigation, mean, these are things that you can plan out. And then if there is a dispute that really can't be resolved, or you're at a stalemate and you're at 50-50, you're 50-50 ownership, and so, voting's not going to work, what do you do? So you can plan out that method of how you may resolve a dispute in this operating agreement or partnership agreement. And most very, very important term to plan out is an exit strategy in case of death, disability, incapacity, or simply one partner is ready for a change. Or somebody comes knocking on your door and they want to buy it, or you want to sell it. How do you handle the exit strategy? How do you transfer the interest, the ownership interest, and in a way that is going to not hinder the process? So many times, when there is an exit happening, time is of the essence. Time is important, and if you drag it on, you might affect the value of your company. And the process for selling the business or a liquidity event, and then also wind down management. So all those things, division of work, property, financial and sweat equity contributions, decision-making process, approval process, proprietary information, exit strategy, all these things can be covered in that partnership agreement or operating agreement that will really smooth the road for the beginning, and the startup growth of the company, the operation of the company, the roles and responsibility, and also the wind down of the company. It'll smooth the road, and it's an opportunity that you have from the get-go to craft terms that work for your partnership and for your company. So as I mentioned, there are default rules. Like if you don't plan these out, then you will be subject to these state statutes that cover businesses in your state. So for instance, absent a provision to the contrary under CULCA, it governs Connecticut LLCs, absent a provision to the contrary, any amendment to the operating agreement must be by unanimous consent of the members. Absent a provision to the contrary, admission of a new member must be made by unanimous consent of the members. That's something that you can change. So you can say it's majority, and it really depends on the makeup of your partners, right? So if you have a husband, wife, and then you have a third partner, then the husband and wife, they're going to want, some of these decisions to be by majority consent, not unanimous consent. If you are the third person, you're going to want it to be unanimous consent because you want your vote to matter. And another thing, CULCA clarifies the extent to which certain fiduciary duties of a manager or member to the LLC may be limited or altered. So you may be able to limit some of the duties that would otherwise be there. So it's an opportunity to really craft the way you run your business, the fiduciary duties you may have, or you might be able to carve some out, which might make it less burdensome. And many other areas that you can really customize the operations of your business and what you would be governed to. So, when any private person, when you have an opportunity to privately contract, you should take that opportunity. Otherwise, whatever the state has on their books as the law will be the default rule. Now, separate and aside from all this, if there are two businesses out there that or two business people who want to get together and form some offshoot company, but they're not ready to really jump in and form an entity and bind themselves together that way, then you may want to consider a joint venture, in which case there are still a lot of the same terms that you need to address, and you should do that in a joint venture agreement. So, but in general, the key takeaway here is that you don't want by default to create this partnership whereby you have all these exposure that is unnecessary. So plan for it, educate yourself, inform yourself by sitting down with professionals and take the time to choose the right entity and formulate your agreement with key terms that really matter to your business and to you as a business partner. And those are the main things that I wanted to leave you with. And then I see we have some questions here. So let's see.
Yeah, so and please feel free to put any questions that you have in the chat, and then Alexis and I will go through them and try to answer them. And the first one's a great question from Felicia, asking how much time do you think you should take before jumping into a partnership? And I'd be curious to hear from Alexis as to, if she's seen trends with there being more legal complications for those who jump into the relationship quickly. From a relationship perspective, my response to this is for however long it takes to feel like you really know the person and can assess those characteristics that I had spoken about. Because for people that take a very short amount of time, they may not have had a chance to really test some of the things that we talked about, or enough time to pass to see red flags that may appear later. Alexis, would you like to weigh in?
Yeah, I mean, I think it's hard to answer, in terms of time period that passed, but I think doing your homework as to what the history of your business partner is pretty critical. I mean, you can do a background check. I know, that might seem like, oh, I don't trust them. If you don't trust them, you shouldn't go into business to begin with. But, if you don't know them well, you don't know the terms of why they departed from previous jobs. You should really dig a little, in my opinion, and maybe talk to some people or talk to them and try to get them talking about why did you jump around so much, or what were the terms of your departure, or you have to try to, really squeeze some information out of them and use your intuition to get a feel for whether, their answers feel straightforward and truthful, and what can you live with. So, time wise, I would say just you have to do your homework and look into their past a little bit.
One other point I'd make, in addition to just the amount of time that you take to get to know someone, is to take into consideration the time and point in life that one is in. Oftentimes, you'll see people form these partnerships, maybe even while they're still students, but they don't anticipate what life ahead is going to bring. And when their circumstances may change a few years out, when they have additional responsibilities, and perhaps can't take the same level of risk that they did when they were single or as a student, or had a fallback.
I would say too, it's also very important, build into that partnership agreement or operating agreement that you will have, periodic assessments, that where you sit down and you really go over the numbers and contributions and plan for the future, and give yourselves a way to continuously have those conversations, so you're not set with the same terms. And that operating agreement, that partnership agreement, really should be a living, breathing document. You should be looking at it once a year or so, once every 6 months, and see what amendments you need to make. So if you're kind of getting the feel like, okay, this person isn't what I thought, or I see things coming down the pike that are not going to work for me, then you might be able to adjust it slightly to protect yourself and to put some checks and balances into place. You can also do that through like an executive services agreement, even if they own the company or part of the company. So another question, would it be possible, this is from Felicia, would it be possible to recommend a strength finder test prior to engaging in a partnership? Felicia, tell me about a strength finder test.
Well, I assume Eileen knows.
Yes.
Like the
Okay, sorry.
buyers or something like that. Like I had a company before and knew nothing about it, any of this stuff. But it would have been nice, like at the beginning, to just, even like hiring employees, like if you could just require them to have some kind of strength, so you can really dive quickly into what their strengths are.
And Felicia, this is exactly what I do as a coach for both individuals as well as teams. And there's a variety of psychometric tests. Actually, StrengthsFinder is a brand name of one of them, but there's several others that are available. And this kind of gets to that point of, if you want to change something about the other person, you're better off changing yourself, because there are certain things that are baked, particularly in terms of thinking styles and preferences and things that we in HR call, one's instinctual self. So there are going to be certain personality traits and thinking styles in addition to actual strengths around skills, that everyone's going to come to the table with. So understanding what they are up front, but also understanding how they can be complementary. And this can be done with whole teams as well as with two people that are in a partnership. And yes, I would absolutely recommend that. I think in terms of being proactive before entering into a formal partnership relationship, that's one of the best things you can do. And it'll give you the foundation to be able to start a lot of other really important conversations.
We have a question from Christina Alvarez. Is there a better state to align your business with where laws are more favorable? I mean, certainly, each state does pass different laws. Most of the states, and I should know the percentage or how many, but most states, at least with the LLC Act, have adopted that Uniform LLC Act. And so it's fairly similar. I mean, everyone's more in line now with Delaware in general. But there are some huge differences between states like Connecticut and California, regarding employment law. I mean, and Illinois and Massachusetts, those are historically employment law related, a lot more difficult to run your business. So that's not specific to business partnerships, but more running your business in general. Absolutely. You should analyze where are you forming? Absolutely. And then this is from Felicia, is it less complicated to do a joint venture than a partnership? I mean, with a joint partnership, you'd want to focus on different things, but what you don't have is to unravel as much. You don't have, specific ownership and equity that you have to figure out what to do with, and wind down an entity, which can be a process in itself. With joint venture, you want to focus more on intellectual property that you both bring to the table and what happens to the intellectual property that's created from the joint venture, and have a plan for that, because otherwise if it's super successful, there might be a lot of dispute over who owns that, because who contributed the most to it. So it should address it. Yeah. So, any other questions? This is from Virginia, when someone takes on an investor, would you consider that a form of a partnership? Absolutely. Yeah, I mean, they could be a silent investor, in which case, they might not have any interest in management decisions. But in some way, they will be affecting your partnership. Absolutely. If it's an LLC and they're an investor and they're going to own a part of your company, you want to plan for that type of taking of an investment upfront with your original partners, so that and there's a process for deciding how involved you want these investors to be, what type of investor you want.
Alexis, I actually have a question. What is most prevalent in terms of the types of issues that are brought to you?
Okay. Well, can you drill down on that a little bit? Like what disputes kind of are raised?
Exactly. When partnerships are not going well and they seek out an attorney, what would you say are the most common issues that
And
are possible.
inequity of us of time and effort being put in, someone not being available as much as the other partner thinks that they're available. It's and I had a situation recently where this company, they didn't execute an operating agreement. There had been an operating agreement being circulated for years, because they couldn't agree on the equity terms, and the sweat equity that was brought to the table that was trying to be, one partner wanted to turn it into ownership interest in the company. And then it bubbled over, right? So this long simmering issue suddenly bubbled over into, one partner essentially taking over. And there were, some family members who had been investors or, had loaned money. And so that, the other partner is now fighting to get his equity out of the company. And it's a very difficult thing and costly to litigate. They're not going to want to litigate. So I would say an inequity of contributions, and faced with, having not executed an agreement, it's he said, she said a lot.
Right.